And this morning on the Ag Issues program, it's always a pleasure to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you. Your air conditioning's functioning again.
Exactly. And it's very temperate in here versus, at least last Monday when you weren't here, and then 2 Mondays ago when you were here as well. All right, let's go into the first topic, and that is drone usage in agriculture. We had a story of this, how popular it's becoming. The market's global drones market size reached $4.7 billion in 2024 and projected to reach a value of $29.1 billion in 2023. So obviously, the popularity is growing in nature. Now, if you are a drone user, you know there are plenty of rules and regulations that you have to follow as well. And that includes the FAA, they are proposing a new rule called the Normalizing Unmanned Aircraft Systems Beyond Visual Flight Line of Sight Operations. As to everything, you have to have an acronym, BVLOS. And I guess first off, explain this rule and why this potentially, it sounds like, could be an improvement on what the current regs are now.
Yeah, well, can we find a longer acronym?
Exactly.
Than that one. Yeah, this one, at the bottom line, it allows you to fly a drone beyond your visual line of sight. That's what that means. And that would be very beneficial to a lot in agriculture, particularly large farms and ranches. But it is a proposed rule. It was proposed by the FAA in early August. We've now gone through the 60-day public comment period that closed on October 4. And they got over 2,000 public comments from people and various industry groups and civil liberty organizations and others about the rule. And they're currently in the process of reviewing those comments, responding to those comments. And it looks like we're set for probably a final rule, I'm guessing February or March of next year, the way the process should play out.
Well, the proposed rule itself, beyond the visual line of sight, is one thing as well. But they have specifics on that, or details on specific things about that, because obviously weight, size, and everything else is involved in this too.
Oh, yeah, and there are safety concerns. And so some of the basic rules here is that you could fly a drone beyond your visual line of sight at or below 400 feet above ground level. Launch it from a pre-designated and access-controlled location, and you're going to have to get FAA approval for your intended flight areas. So that's one of the rules that's out there. That's more safety concerns than anything else on that one. And the rule covers drones or unmanned aircraft systems, UAS, which is the official title on this, that weigh up to 1,320 pounds, including the payload. So these are big drones. These are not the typical ones that we've used in agriculture to scout crops or to scout livestock. These can actually do certain things, maybe apply herbicides, apply chemicals to crops, those types of things. Drones would not be required or would not require traditional FAA airworthiness certificates, but what the proposed rule does is establish a process for accepting the airworthiness of an aircraft based on industry consensus standards. Now, we're going to have to see what the final rule says with respect to that, because there's a lot of flux in that. That really needs to be filled in on what that means. And then they'll issue permits for lower risk operations with limited fleet size, weight, and scope, agriculture, package delivery, those types of things. And then certificates would be required for higher risk operations involving more thorough FAA review and oversight, including safety management training programs. Again, the details are going to be in the final rules that come out on this one.
And the benefits for farmers and ranchers, specifically for agriculture and even aerial surveying, are pretty beneficial in this too.
Yeah, it definitely can be. These rules are explicitly intended to expand drone use in sectors that have large swaths of land, and that would be agriculture, and that would include, as you indicated, aerial surveying. And so, if I'm able to fly a drone beyond my line of sight, that should bring greater benefits to me in terms of efficiency and the scope of usage. Now, with anything, Greg, there's a cost to adopting this technology. And so we should be measuring that cost of whether I want to use drones in this way against my anticipated economic return to make sure that there is an economic benefit to my use of precision. It's early in the morning. Precision. This is why I don't record my daily radio program at 6 in the morning. Precision agriculture. And so you need to do a cost-benefit analysis, but it will allow you to cover larger areas and surveying areas in the West in particular that are very difficult to survey is going to be a big issue. I didn't mention this to you that we talk about this. I just thought of it. The mod problem in South Dakota. Over the past couple of years, that situation's not over. But what that resulted from, Greg, was there had been a fence separating the Forest Service land from the mod's private property that had been in Charles's family for many, many years, decades. And there was new GPS technology that was adopted to determine the actual survey line, the boundary line. And that's where that whole case came from that eventually got to the President of the United States and forced the USDA to drop the criminal charges against the mods. So this can be used in a good way. It also can be used in a bad way, too, and can create additional problems. But crop monitoring and livestock management and water management, those are all going to be benefits of being able to fly a drone beyond your visual line of sight. So, if you get out west, you can inspect miles of irrigation systems and pipelines or water sources for leaks or blockages. Conceivably, the idea here is that leads to better use of water, less waste of water. If I'm going to use it to manage my livestock, I can quickly monitor herds that are scattered over large and remote pastures. I can check my fence lines. I can locate missing animals perhaps more efficiently than what has traditionally been done. And with crop monitoring, I can survey hundreds of acres to detect nutrient deficiencies and pests and disease. And hopefully that leads to specific site treatment that would result in greater yields that would increase my profitability. But that's the bottom line analysis that a farmer would have to use. If I'm going to increase my yields into a market where the prices are already below my cost of production, then it doesn't make sense to do that. So there's a whole host of economic decisions that have to be made here and a lot of calculus that has to be done before you decide to adopt the technology. But conceptually, yes, it would benefit farmers and ranchers dramatically, and we'd see significant improvements in efficiency and scope, at least in theory. And
even for that, sometimes you have to have observers looking at things or monitoring where that is going, or even sometimes you got to have a manual pilot who is taking that manually to be able to do that. I would think it would at least hopefully take away, or you don't have to do that necessarily all the time as well with the new rules.
Yeah, and I think what you're saying there, at least implicit in what you're saying, what I'm hearing is there might be some safety benefits to this too. If I don't have to put a pilot in an airplane to go crop dust, but I can do that with a drone, I can remove the human factor out of that, and if there's an accident, we're not going to lose somebody's life in that instance. So, yeah, and I do know that the crop dusting companies are looking at this significantly as a technology they would like to adopt. So we'll see. I think there's good promise in this, but again, it's all going to come down to the bottom line economically. Is it worth it to me, bottom line, to adopt this technology? Or do I end up driving myself further in the hole? That's the question that people are going to have to ask and analyze. Sit down with their accountants, sit down with their economic and financial advisors, and determine whether this is a good thing to do.
A question that's probably not asked enough in this current day and age right now.
I think that's correct, yeah. You look at We hear a lot about down crop markets, but we don't hear the other side of the story is that farm income is going to be up this year, and that's because cattle markets are very good. So the projection, I've seen projections in Nebraska that farm income is going to be up 55%. That's driven by the cattle side. But if I'm 100% on the grain side and I'm pretty much monoculture into corn and soybeans, it could be rough. But there are things that we can do from a tax standpoint and from a marketing standpoint to help with that profitability and help that bottom line. But I think you're right, Greg. After all of these years of talking about these things, I still think there are a lot of farmers out there that are underutilizing the tools that are available to them.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, the next topic is really a lot of Kansas producers may be under this. This is livestock sold on account of drought and deferral of gain as well. This has to do as well with the IRS issuing its annual notice providing an extension of the replacement period for farmers and ranchers who were forced to sell or exchange livestock due to severe drought conditions.
Yeah, this is a tax provision, Greg, and what this really stems from a number of years ago. It was over 20 years ago. There was prolonged drought in western Kansas, and the Kansas congressional delegation really helped get this provision through. We used to have a rule that says if I have to sell more livestock in a particular tax year than I normally do, and it's on account of drought or weather-related condition, it's been broadened, I don't have to get stuck with the tax bill for that excess over what I normally would sell in the tax year, because that would create a problem for me if I got hit. I got a down year, things are rough because of drought, and then I sell excess head, and now I've got a major tax problem because of that. And so Congress said, well, you've got 2 years to replace. Then they extended it because of the prolonged drought in western Kansas. They changed the statute to 4 years, and then they said if drought continues to persist, then you can get an additional 1 year on your replacement period, 1 year at a time. And by the end of September every year, the IRS is to come out with their list of what's known as the so-called drought counties. And the University of Nebraska-Lincoln has a drought monitor where you can see where all these are at, or you can wait for the IRS to put out their announcement. And they did. They actually did it a week early this year, which surprised me. I was on the road and I saw that, and I thought, wow. With all the cuts, it's still amazing to me that IRS is staying up on guidance on the One Big Beautiful Bill Act, and then we get this a week early. But basically the counties, and I know I have them listed for you, Greg, but when you map those out, it's interesting this time your drought counties are the eastern half of Kansas, and along the Oklahoma-Kansas border from basically Wichita west, and then spotty in the southwest and west, and really not much in the center of the state. Interest, I've never seen those counties be listed like that, where it's much heavier on the eastern side, where your drought counties were at over the past year, September to September, than out west. But that's where you're at. So these people in these counties get an additional year to replace the animals and defer the gain on the excess.
And incidentally, right now, the driest areas in the far eastern part of the state now, too. So.
Yeah. No, we got good moisture in western Kansas this year, out in western Nebraska and in your panhandles. It's not bad.
Yeah, not bad at all. All right, let's move on to another topic here. This is tax valuation, but impacts on wetlands.
Yeah, this is a South Dakota case. It's a recent opinion of the South Dakota Supreme Court. And here we had landowners that owned 2 tracts of ag property, and they were those tracts were subjected to perpetual federal wetlands reserve easements. And, of course, if that's a perpetual easement, that's going to permanently prohibit most of the ag activity on the land, and it's going to restrict the land's use and marketability. Well, the county came in and assessed the properties using the statutory productivity-based valuation method, which is not unlike unlike what we have in Kansas with respect to agricultural land. It's supposed to be based on productivity to an extent. And that resulted in assessments of over $1,600 to $2,200 per acre. And the landowners appealed that, arguing, wait a minute, that's way too high, and it violated the South Dakota Constitution. And they presented testimony in a broker opinion report that said that the actual market value was roughly $800 to $1,250 per acre due to the easements. And so you get into the administrative process here, and you had an administrating hearing officer that and the circuit court, the local trial court, that affirmed the county's assessment and said the landowners failed to rebut the county's presumption that the assessment was correct because they didn't present a certified real estate appraisal. Well, this goes all the way to the Supreme Court of South Dakota, and the Supreme Court reversed, sent the case back to the lower court, and they said that the state constitution and the statutes don't require a certified real estate appraisal as the only way for a taxpayer to prove the actual value of their property in a tax dispute. And they said you can use credible testimony from witnesses such as real estate brokers or the property owners themselves, and that can be sufficient to rebut the presumption of correctness given to a county's assessment. And because there were errors on that point made below, that's why the Supreme Court kicked it back for a do-over on that one. But basically, what the importance of this one to us, even though we're not in South Dakota, Greg, we have a similar process here. And you had the Supreme Court in South Dakota that said, well, yeah, county, you did follow the procedure properly for assessing ag land, but the resulting value can still be unconstitutional if it clearly exceeds the property's actual market value. And you're not just limited to a certified appraisal. So basically, the point here is, Greg, if I'm going to buy farmland that has a perpetual conservation easement on it or a wetland easement, what would I pay? What would a willing buyer pay a willing seller, each having full knowledge of all the relevant facts of the property? And you're not going to be locked into a county's appraisal approach given that. The court's going to look at all the evidence, and if there's just no market for it at $1,600 to $2,200 per acre, then it's worth less. And I think the court got the right result here, even though they said the county, yeah, you followed the right procedure, but even following the right procedure could end up with the wrong result.
But if there's, I don't know how much often this happens, if there's a bidding war for that land,
sure, then
it reads in completely different in that aspect.
It does, and sometimes we run into that in agriculture. I've seen examples of that, many instances. Agricultural land doesn't hit the market that often, and there may be a tract that's right adjacent to you, and you're willing to pay a significant amount above market, so-called market value for that just because of its location and maybe what you need it for. For example, in northwest Iowa, a farmland that is nowhere near any type of urban area at all will sell at a very high price because maybe it's an extra 40 or an extra 80 that they need to put hog manure on. And it's in a prime location. And so we'll see those values go $25,000, $30,000, $35,000 per acre for an 80. Now, that's an 80 that becomes a piece of a larger farm. They're not going to farm off of that because that's not profitable. You can't cash flow that. But very unique set of facts, and you can see that happen. So you're right.
All right, Roger, we're out of time, but as always, if people want more information, they obviously can go to your blog to get more information or to your Substack as well.
Yeah, the drone article is going to go up on the Ag Manager website at K-State this morning. I'm still trying to figure out my own blog. The platform went down, and we switched it. It got switched over to Lex blog, and I'm still trying to figure out how to add things to that. But this will go to Ag Manager at K-State. That's agmanager.info later this morning.
Oh, the World Wide Web.
Mm-hmm.
All right, sounds good. Roger, as always, appreciate it. Thanks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.